Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflicts or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. If you are new here, welcome. We do have a lot of new subscribers. Welcome. Thank you so much for committing and supporting to the channel. And if you've been here before, thank you so much for rocking with your girl. You guys know from the thumbnail, we are here to talk about Bishop T.D. Jakes. For those of you that don't know, Jakes had a rough year, which there were a lot of allegations that were floating around. It started with Diddy and people were speculating, and there was an interview by that was held on Larry Reed Live's platform, of which Duane Youngblood, who is a former bishop, I don't think he's a bishop anymore, but he alleged that there were some actual type advances that occurred at the hands of T.D. Jakes. And so after the interview, he did one interview on the platform, and then I believe he came back for a second interview. And at that time, T.D. Jakes said enough is enough, and he went on ahead and he filed a lawsuit over in Pennsylvania. One of the things that we did discuss is, well, first of all, let me give this disclaimer. Reading this opinion, I just glanced through it. It's going to be nice and boring, and it's going to be similar to like what we as attorneys have to read when it comes to the law aspect. And typically I try to skip as much as I can, but literally this whole document is premised on, it took me back to law school. I almost had PTSD, all right? One of the issues was, and I told you all before, that Pennsylvania just now enacted, I don't even think it's been a year, they're anti-SLAPP. So what happens is when you enact the anti-SLAPP, which is it's basically a way to dismiss the case early on, and I explained to you all several times the purpose of its enactment in many states, such as California, New York, Nevada. There's a lot of states that have it, especially those with celebrities, because what was happening was that people will file lawsuits knowing you're the little guy, and then you don't have the money to fight the fight, and so you just give up. And so because of that, the money from big corporations were being used to basically silence the little guy who had opinions, because they just couldn't afford to battle it out with them in court. So what the states did is that they said, hey, we're going to enact those, not every state, but specifically those states that I named, and there are some more, we're going to enact a similar, a dismissal type statute, and you call it the anti-SLAPP, of which when you can respond as your first response saying, listen, the purpose of this is just to stop my freedom of speech. That's it. The purpose is to stop my freedom of speech. They shouldn't be allowed to do that. And then what ends up happening is, if you can prevail and the court says, oh yeah, this is pretty much, an anti-SLAPP, a SLAPP type issue, you can ask the other side to pay your attorney fees. So it made it more of a fair fighting ground. So that was the purpose of it. Well, in Pennsylvania, as I told you all before, Pennsylvania just now enacted their statute. And one of the issues that they have with anti-SLAPP is in every state is different on whether it applies in federal court. So this was enacted by the state legislature. You have your state court and you have your federal court. And so you have some states of which they've made the decision based on the analysis, basically under what's called the Erie doctrine. As long as it does not conflict with federal court rules, it can be in state and federal court. So there is a split. You have some states of which the anti-SLAPP can be applied, or anti-SLAPP type statutes can be applied in federal court and state court. Then you have some courts of which the court has determined that it can only be applied in state court and doesn't apply in federal court. Well, in the Jake's response, they challenge whether that statute, the anti-SLAPP, should even apply in federal court at all. And they did a nice analysis under the Erie doctrine. However, in my opinion, I feel like the response, so that's the biggest issue, okay? To strike that. That's the biggest issue. If it doesn't apply and you filed a whole motion to dismiss under a statute that has not been enacted yet, your whole dismissal is going to be dismissed, okay? So if you don't thoroughly analyze why the anti-SLAPP statute should apply in federal court, nothing else that you say matters. So when Jake's people responded and they said the anti-SLAPP does not apply in federal court, the reply to that by Duane Youngblood's team should have been explaining exactly why it should apply. And there are reasonings out there, because the law firm that actually, I think they take credit for helping to draft the statute for the legislature, said they did it in a way for it to apply in federal court. And they did what's called an amicus. And they, in another case, I think it was the Trump and the exonerated 5 case, because Trump got sued for what he said about the exonerated 5. So they said that it was meant to apply. When I saw Youngblood's reply to their response, there was very little analysis on why it should apply, which I think was not a good thing. All right. Because the thing is this: if the statute doesn't apply, your whole motion doesn't mean anything. It don't matter. You can be right that it wasn't defamation. You can be correct that it wasn't a conspiracy. You can be correct in all of these different avenues. But if the statute don't apply, your motion don't matter. So what you're going to see is a bunch of procedural type analysis within this order. Because, to be honest, we really ain't get to the substantive, because the court dwelt primarily, from what I saw, on the procedural part. So there was a win on Jake's side, because the judge denied their motion to dismiss this case, which means that Duane Youngblood is going to have to fight this fight against someone that got a whole lot of money. And this is where we are right now. So that's just a summary, so you guys know when it gets boring up in there, that's why. Because the court is going to do what we had to do in law school when we had civil procedures, and we had to decide if certain cases can go to federal court and if certain rules apply and if it's not in conflict and all of that. And the court was very heavy on that. And there are people that I talked to about it that can vouch that I said I think it was a bad idea not to thoroughly try to analyze that and just brush over it. Because the bottom line is, if it doesn't apply and that's what you base your motion on, your whole motion don't matter. So how do you just do a paragraph or whatever on that instead of a whole analysis like what Jake's team did? So that's my intro, okay? Because we're gonna get into it. It was like 18 pages, and it's not going to be what people think, because typically we look through and they talk about whether truth is the defense. They're going to talk about, all of that, but you don't get to that at all if the court says the statute don't even apply. All right. So I hope y'all understand, because I'm sure when it gets analyzed in other platforms that have been covering this, because they don't really know the legal, they'll probably watch this and just don't give me credit. But because they don't know the legal rationales behind it, it's just going to be looked at like, because Youngblood, maybe his history, or because it was defamation, or because it was this or that. That's probably what their analysis is going to be, because a lot of people, they don't want him to win because they don't like his black background. For a lot of y'all that don't know, Youngblood spent time in prison for messing, I guess, with a young boy. He is a registered offender. And that alone has made everybody who's discussed this be like, we want him to lose, period. How is he bringing a lawsuit? How is he talking about something happened to him when he did that to other people? That has been the crux of this, and it's been a divide, because people can't take away the emotional aspects of it, because we are humans. We don't plug ourselves in every day, and they focus on that instead of like the status of the law. So Morky's mom said it takes a little legal knowledge to follow this. You have a truly intelligent following, but we still like potato salad and no raisins in it. I'm going to try my best, okay? I'm going to try my best. Hey, Really B, I'm going to try my best, y'all, all right? I just want y'all to hang with your girl, okay? I just want y'all to hang with your girl. Shauna Boy, thank you for the super chat. Thais. Now, Thais can vouch, because we've been talking about it. That's been over on, he's talked about it a lot on his platform. And I've talked about it when kind of the documents come out. We had a conversation, and I told him I think it was it should not have happened. I think it was a mistake not to actually put the pressure behind why this should apply in federal court and not state court, because we are in federal court. So if it does not apply in federal court, your whole pleading does not matter. And it was literally a 2-page, because you have a limit when you reply. The court don't want y'all redoing 50 pages and relitigating and re-arguing, so they give you limits. Thank you. So I'm not telling y'all nothing, like, I'm just saying that because the way it came out. And so his response, they spent a lot of time on a cross claim, as if he doesn't have the right to cross claim anyway. The reply just wasn't adding up for me. So I'm about to pull it up real quick. I done did my little intro. People that's gonna come in could come in. Make sure you hit the like button and all of that good stuff. And again, I just kind of scrolled it. Let me take myself off this thing. So when you look at the opinion, it has the plaintiff, Thomas Dexter Jakes, brought this action against defendant Duane Youngblood and 10 identified individuals. At count 1, brought against Youngblood, Jakes alleges that Youngblood engaged in libel per se. At count 2, he brought against all defendants. Jakes alleges that defendants engaged in a civil conspiracy to commit defamatory acts. Youngblood filed a special motion to dismiss pursuant to the Pennsylvania anti-SLAPP statute. For the reasons articulated below, the court will deny the motion. So the court has denied his motion to try to dismiss this case. Okay. This is the factual. I'm gonna need y'all to focus, because you're gonna get lost in the sauce real quick if you don't follow. Because again, this felt like I was going back to law school and I almost got the shakes. Okay. So factual and procedural background. On October 28, 2024, Youngblood was interviewed by Larry Reed Live, who will be identified as LRL throughout this document, online video podcast. The episode was allegedly titled "The Abused Become the Abuser." During the interview, Youngblood alleged that Jakes groomed and actually abused him when he was 18 to 19 years old. Specifically, Youngblood alleged that Jakes attempted to kiss him and subsequently called him on the phone and made statements regarding future actual encounters between Jakes and Youngblood. Youngblood stated that the encounter between himself and Jakes was, quote, absolute destructive actual damage, end quote. Youngblood described another conversation that took place with Jakes years later, where Jakes allegedly stated that, quote, my stock was rising. I would have had X with anybody at that time, end quote, in reference to the prior alleged interactions between Jakes and Youngblood. On November 3rd, 2024, a second part of the LRL episode aired. In that episode, Youngblood repeated his previous allegations towards Jakes. Jakes subsequently brought this lawsuit under the court's diversity jurisdiction against Youngblood, alleging that Youngblood's allegations are, quote, patently false and defamatory. At count 1, Jakes alleges that Youngblood's statement on October 28th and November 3rd of LRL are libelous per se, in that they expose Jakes to contempt, ridicule, and tend to affect Jakes in his profession as a trusted pastor and religious figure, and accuse Jakes of engaging in unlawful conduct. At count 2, Jakes alleges that Youngblood, along with 10 unidentified defendants, acted in concert to publish and broadcast the false claim that Jakes groomed and actually assaulted Youngblood on a podcast reaching over 100K persons, knowing that making such false claims on a podcast that reaches such a broad audience, a listener would harm Jakes. Youngblood filed a special motion to dismiss pursuant to Pennsylvania anti-SLAPP statute, arguing that 1, Youngblood's statement are protected public expression. 2, Jakes cannot establish a prima facie case of defamation or civil conspiracy. 3, public policy and Pennsylvania anti-SLAPP statute support dismissal of Jakes' complaint. And 4, Youngblood is entitled to attorney fees. Youngblood also requests leave to file a cross complaint, which I just didn't even understand this part at all. I'm going to be honest with y'all, against Jakes and his son, because there's nothing that stops him from filing a cross complaint regardless. Jermaine Jakes, in relation to a message Jermaine Jakes sent Youngblood via social media. So the court analyzes and said, the court will deny Youngblood's motion brought under the Pennsylvania's Uniform Public Expression Protection Act. Youngblood filed a special motion to dismiss pursuant to the Pennsylvania anti-SLAPP. Youngblood did not mention Federal Rules of Civil Procedure 12b-6, nor did he address Rule 12b-6's legal standard. Instead, Youngblood focuses exclusively on the Uniform Public Expression Protection Act. The Uniform Public Expression Protection Act is often referred to as the anti-SLAPP statute. Although SLAPP, which is an acronym for Strategic Lawsuit Against Public Participation, does not appear in the Act's title, the Uniform Public Expression Protection Act is considered an anti-SLAPP. SLAPP lawsuits are generally meritless suits brought by large private interests to deter common citizens from exercising their political or legal rights or to punish them for doing so. So that's what I was explaining in the beginning, that the purpose was the purpose of people that file lawsuits, because they know you ain't got $1 in your pocket, this is the way to deter people to stop people from coming against just the average citizen who is trying to exercise their freedoms under the Constitution. Of particular importance to Youngblood's motion is sections 8340.6, 8340.15, and 8340.18. The court will address the application of each section in turn. For the reasons articulated below, the court holds that 1, section 8340.6 is not effective. And we talked about that before. So what 8340.6 is there is a a rule section, if you will, in that statute. So it'll tell you the rules, like you have this many days to file, you can get attorney fees, you can do it has rules, right? So that's within the statute. The thing about it is, in Pennsylvania and probably most states, I know it's like that in Michigan, the Pennsylvania Supreme Court are the only ones that can enact and approve the court rules, if they're rules, right? And so in this case, the Supreme Court had not approved the rules. So they don't apply until the Supreme Court approves the rules. So that portion of the statute doesn't even matter. It's not in effect, which means you have to use the federal court rules. It doesn't mean you can't use the statute. It just means that part doesn't really matter because it's not enacted yet, because the Supreme Court has to be the one to approve it. The Pennsylvania Supreme Court at that, not the United States. Second, section 8340.15 is not applicable in federal court. And 3, section 8340.18 is not relevant at this stage of litigation. So there's three different portions of the statute, and the court is going to go over all of them. Pre-trial motion. Youngblood purports to rely. Hold on. Yeah, can we get these likes up though? Because y'all got me actually doing way too much. Rick Pat said T.D. Jakes 05 $4 million jet hangared in South Dallas, and whenever he was there using it. Oh, okay. Hey, Miss B, good to see you. All right, y'all. Youngblood purports to rely on 42 PACS section 8340.16 as the mechanism permitting him to file his special motion to dismiss pursuant to the Pennsylvania anti-SLAPP. The court holds that section 8340.16 has not yet taken effect. A party may file a special motion for dismissal of or judgment on a cause of action or part of a cause of action based on a party's protected public expression immunity. In ruling on the special motion to dismiss, the statute directs the court to consider the special motion to dismiss, responses, and the evidence which can be considered on a motion for summary judgment. The act establishes a procedure that shares many attributes with summary judgment. So, consistent with summary judgment practice, parties should submit admissible, competent evidence such as affidavits, depositions. Basically, when you're in federal court, you can do a motion to dismiss, 12B, or you can do a motion for summary judgment. When you do a 12B motion, it's basically only on the document. So that means you file a complaint against me. I respond and just say you failed to state a claim, period, based on the document. I can't attach anything. I can't give affidavits. I can't show my evidence yet because I'm doing it based on the pleading. When you do summary judgment, typically you go through discovery first and then you do a summary judgment. Discovery is when we both sides give information. I'm going to give you a set of interrogatories or questions, request for protection of documents, and I'm going to get your answers. After I get your answers, I'm going to set up a deposition. You don't have to do any of this if you don't want to, but you have a discovery process of which you get information from both sides. Once you get information and you feel like you have enough that you can basically ask the court to dismiss it on a summary judgment, you are allowed to go outside of the pleading and you can attach exhibits and documents. The anti-SLAPP acts more like a summary judgment. So when you do an anti-SLAPP, you can attach your evidence, which is similar to a summary judgment. So that's kind of what they are explaining by saying that the anti-SLAPP shares similarities to the summary judgment. Okay. So then it has the Supreme Court of Pennsylvania has not promulgated any rules or issued a direct letter of address regarding section 8340.16 or any similar provisions. That's what I was just explaining to you all. The Supreme Court of Pennsylvania has not enacted those rules, and they are the body that is supposed to be the ones to enact rules in Pennsylvania. Okay. Thus, Section 8340.16 is not effective and has no bearing on this litigation. It is not operative law. Youngblood purports to file his special motion to dismiss pursuant to 8340.16's mechanisms. His motion must fail on procedural grounds as the subsection under which it was brought is ineffectual. Since Section 8340.16 is not good law, Youngblood's motion may not proceed under this section. What's this? Since Section 8340.16 is not effective, the court does not even reach the issue of whether it would apply in federal court. So when it comes to that section, they don't even get on that because they're like, it's not even effective yet. So we're not there yet. So then you got grant of immunity. This is the 8340.15 section. Youngblood alleges that he is entitled to immunity and judgment as a matter of law because his statements are supported by affidavits, public reports, and corroborating testimony. And Jakes has not, quote, demonstrated actual malice or falsity. Youngblood repeatedly states that Jakes has, quote, failed to provide credible evidence to meet the burden. Youngblood filed a multitude of exhibits with the court that allegedly support the truthfulness of his statements. Jake counters that Section 8340.15 does not apply in federal court because it conflicts with the federal rules of civil procedures. Thus, the first issue before the court is whether a federal court exercising diversity jurisdiction, and diversity jurisdiction means because Jakes is from Texas and Youngblood is in Pennsylvania, they can file in federal court under diversity jurisdiction. So you can file under diversity jurisdiction or if there's a federal question to get in the federal court. So thus, the first issue before the court is whether a federal court exercising diversity jurisdiction may apply Section 8340.15, even assuming that Section 8340.15 could apply independently of 8340.16, the court holds that 8340.15 does not apply in federal court. The court acknowledges that there is a disagreement amongst courts as to whether a federal court exercising diversity jurisdiction can apply a state's anti-SLAPP law. While other state laws are not identical to Section 8340.15, these cases provide persuasive guidance to the court. So then they have cases from Maine, they got cases from the DC area. Okay, and Amicus, the United States Court of Appeals for the District of Columbia, held that a federal court exercising diversity jurisdiction must apply Rule 12 and 56 instead of DC's anti-SLAPP Act special motion to dismiss provision. So then they talk about what these courts had to say. And the DC court determined that the anti-SLAPP conflicts with federal rules by setting up an additional hurdle a plaintiff must jump over to get to trial. So then we get to what's called the Erie doctrine. That's when we really get into law school. Oh, Lord. Y'all got me working. I can't. Shay Bay said you always keep us updated. I'm trying. So Morky Mom said this is great news in her opinion. Thank you so much. Uncle Mario said I'm looking studious. Thank you so much. I appreciate that. So then we get into what's called the Erie doctrine. And in Jake's response, they highlighted and analyzed quite thoroughly the Erie doctrine. Pursuant to the Erie doctrine, a federal court sitting in diversity must apply state substantive law and federal procedural law. This substantive and procedural dichotomy of the Erie rule must be applied with the objective that in all cases where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the parties, the outcome of the litigation in the federal court will be substantially the same so far as legal rules determine the outcome of a litigation as it would be if tried in state court. So basically, under the Erie doctrine, if you are bringing a case in federal court pursuant to diversity, meaning you live in this state, I live in this state, This company is in this state, I'm in this state, and you do it under diversity, you have to have it where federal court, let me see how they put it. Federal court must apply the state substantive law. So when it comes to like, what's defamation? What does the court define as defamatory? What does the court define as a civil conspiracy? All of that is going to be state cases, like the state law. But you would use federal procedures. So you have the federal rules of civil procedures is what you would use. So there's a split. So you use the state substantive law where you sitting at, but you use the federal rules in order to conduct the case. I hope that makes sense. So this outcome determinative test, however, should not produce a decision favoring application of the state rule unless it furthers one of Erie's twin aims: discouragement of forum shopping and avoidance of inequitable administration of laws. Consistent with this aim, the court must apply a three-part test to decide whether a state law or rule is substantive or procedural for Erie purposes. First, the court considers, quote, whether there is a direct collision between a federal rule and the state law or rule that the court is being urged to apply. If there is a direct conflict and the federal rule is constitutional within the scope of the Rules Enabling Act, the court must apply the federal rule in any analysis. In other words, a federal court exercising diversity jurisdiction should not apply a state law or rule if, one, a federal rule of civil procedure answers the same question as the state law or rule, and two, the federal rule does not violate the Rules Enabling Act. I know this is some boring stuff because this is how I felt when I was in law school, okay? So the court holds that there is a direct conflict between section 8340.15 and Rule 12b-6 and 56. For the category of cases that it covers, section 8340.15 essentially supplants the Rule 12b-6 motion to dismiss standard with the Rule 56 summary judgment standard. Rule 12b-6 and 56 help from an integrated program for determining whether to grant pretrial judgment in cases in federal court. I don't even feel right putting y'all through all of this. I'm sorry. I'm so sorry, y'all. I'm I might have to fast forward through this because I'm getting annoyed reading it. So thank you, Lisa. But yeah, yes, Jakes does have good. I mean, why wouldn't he have good attorney? He got a couple of firms on there. You said Jakes got some very good attorneys. Why wouldn't he? I mean, let me see how I can skip this because we be here all day. This 18 pages. Oh, Jesus. So, in accordance with the Erie doctrine, this is the ultimate conclusion. In accordance with the Erie doctrine and Shady Grove, the court holds, one, there is a direct conflict with section 8340.15 and rules 12 and 56, and two, rules 12 and 56 are constitutional and within the scope of the Rules Enabling Act. The court must apply Rule 12 and 56. The procedural mechanisms established by 8340.15 cannot apply in federal court. Since the court cannot apply section 8340, the court will not consider Youngblood's argument brought under the statute. So basically, you lost off a procedure, is what they're saying. They didn't get to the substantive. That's what I was telling you all. Like, before people get all, you didn't even, because basically they're saying this statute doesn't even apply. I don't know if I necessarily, when I read the Amicus brief, let me pull up that real quick, where the individual, according to them, which is actually, I believe they're the same attorneys that Tasha K uses. They're like some of the top civil rights attorneys. Let me see. Let me pull this up right quick. So in this case, which was with Donald Trump, when he tried to do it, the ACLU talked about it. And they did a whole analysis, and I think it would have been, So in this case, they said they basically want to let them know they ain't taking no position. They just saying what they think the statute was meant for, like that it actually does apply in federal court. In this case, defendant Donald J. Trump has filed a motion to dismiss in which he argues, among other things, that he is immune from plaintiff's claims under the statute, the anti-SLAPP, and that to that extent that the statute grants him immunity, he is entitled to his attorney fees and costs. In response, plaintiffs argue that the court need not address it, but suggest that if it does, the law should not apply in federal court. The brief takes no position regarding the pending motion or the merits of the case. Instead, Amicus writes for the sole purpose of advocating that if PA-UP-EPA standards are met, the law's substantive provision, namely its immunity and fee shifting provision, can and should be applied in federal court. If the court were to determine otherwise, PA-UP-EPA would be rendered less effective. Its objective of discouraging forum shopping and protecting speakers in Pennsylvania would be severely undermined, and the legislature's unanimous intent to encourage speech on matters of public significance would be thwarted. So there was a whole ACLU argument. Look how thorough this argument is, and it's by Ballard and Spahr. Like I said, they are one of the top First Amendment law firms. And on their website, they said that they had a hand in drafting it. They said they specifically made it, I guess, so that it can apply in federal court. So this is the whole analysis right here. So on another note, where you be touching on the Wisconsin, I haven't seen that, E-Boogie. I haven't seen that, but I'm gonna need. Yeah, it is. It's been real busy. Okay. So let's put this back up. So this is the part about awards under section 8340.18. Youngblood seeks attorney fees. So this is the other part. Awards attorney, the section 42 PACS, it awards attorney fees, court costs, and expenses of litigation to defendants who engage in protected public expressions if the court finds that the defendant is immune under section 8340.15 or the opposing party voluntarily discontinues this action. On the other hand, if the court determined that a party's assertion of protected public expression immunity is frivolous or filed solely with intent to delay the proceeding, the court shall award the opposing party attorney fees, court costs, and expenses. So in the Donald Trump case, it seems like the court may have went the other way. They're in the Eastern District of Pennsylvania. We're in the Western District on this case. And right now, as we speak, because Donald Trump lost that, the exonerated 5, I believe they filed a motion for attorney fees. I haven't read it yet, but yeah, I think they filed. So this is a part where whoever prevails under this statute, you can get attorney fees and costs. As noted in the prior section, 42 PACS 8340 and 8340.16 respectively are not applicable in federal court, and 2, not effective law. Consequently, the court will not make any findings with respect to whether Youngblood or Jakes is the prevailing party. So there ain't nobody a prevailing party. The court holds the section 8340.18's award of fees is inapplicable at this stage of litigation, and at this time, it will not reach the issue. So they ain't even talk about it. So then they go on to there is no motion to dismiss pursuant to Rule 12b-6 pending before this court. Youngblood's special motion to dismiss pursuant to Pennsylvania anti-SLAPP statute is based entirely on the Uniform Public Expression Protection Act. In his motion and supporting brief, Youngblood does not mention Rule 12b-6, the governing rule at the stage of litigation. Moreover, Youngblood's motion is reliant on the summary judgment-like standard. This court will not reframe Youngblood's motion as a Rule 12b-6 motion. Youngblood relies on sworn affidavits to allegedly corroborate his statements and support his arguments. The court may not consider documents outside the pleadings. That's what I was explaining under 12b-6. You don't consider documents outside of the pleadings. Moreover, Youngblood's arguments are fundamentally incompatible with Rule 12b-6 standard. For example, Youngblood argues that Jakes has not presented admissible evidence to prove that Youngblood's statements were false and made with malice. Plaintiff cannot meet their burden of proving falsity or demonstrating that the defendant's statements lack substantial truth. Plaintiff has failed to present admissible evidence of reputational damage directly resulting from defendant's statement. Youngblood further contends that Jake fails to establish by clear and convincing evidence that Youngblood acted with actual malice. Youngblood's motion based on the Uniform Public Expression Protection Act fundamentally diverges from the Rule 12b-6 standard. At the motion to dismiss stage, Jakes does not have a burden to present admissible evidence. Before discovery and trial, Jakes has no obligation to prove any of his claims by clear and convincing evidence. His burden at this stage is merely to allege sufficient facts that, if accepted as true, state a claim for relief plausible on his face. So like I told you guys, it's just about the pleading itself. Moreover, Youngblood's arguments rely on matters extraneous to the pleadings that the court may not consider. Given that Youngblood's motion is incompatible with Rule 12b-6 standard, the court cannot reframe Youngblood's motion into a motion to dismiss based on Rule 12b-6. The court's role is not to craft arguments for the parties. So basically, you didn't do what you were supposed to do, and the court ain't going to fix it for you. All right? It is the responsibility of neither the district court nor the court to make the parties' arguments for them. Therefore, we will not engage in a freewheeling investigation into legal issues without meaningful briefing on the subject. Then they got the case that stands for that proposition, Hunt Optics and Imaging, Inc. And then it is the parties' duties, not the courts, to present legal authority and arguments in support of a motion. The court will dismiss Youngblood's motion because it relies on statutory provisions that are not applicable in this litigation. So again, the court is dismissing the motion because it relies on statutory provisions that are not applicable in this motion. The court will not reframe Youngblood's argument to fit within the Rule 12b-6 or Rule 56 framework. If Youngblood wishes to file a motion to dismiss based on a Rule 12b-6 or Rule 56, he may do so, provided that his filing complies with all applicable federal rules of civil procedure. And then he goes down to the footnote. So y'all, you hear this? You can refile, but do it correctly under 12b or a 56. The court has the authority to convert a Rule 12b-6 motion to dismiss to a Rule 56 motion for summary judgment. The court is not required to do so unless matters outside the pleading are presented to and not excluded by the court. Here, I'm reading a footnote. Here, the court is excluding all matters extraneous to the pleadings because in Part 1, this motion is not a proper motion to dismiss in accordance with Rule 12b-6. And 2, that would not best serve the efficient progression of this litigation. And the court will not convert Youngblood's motion into a Rule 56 summary judgment motion. Then the court goes on to this whole cross-claim situation. Remember, if you guys recall, like I said on the reply, he spent a lot of time talking about why he want to sue, cross-claim, and sue Jermaine Jakes. And the court basically said Youngblood does not require leave or permission from the court to do a cross-claim. The court will deny Youngblood's motion to file a cross-claim against Jermaine Jakes. Youngbloods request the court to leave to file a, quote, cross complaint against Jakes and his son, Jermaine Jakes, in relation to a message Jermaine Jakes allegedly sent to Youngblood via social media. The court interprets this as a request to file a counterclaim against Jakes and a request to join Jermaine Jakes as a counterclaim defendant. First, the court holds that Youngblood does not require the court's leave to file a counterclaim against Jake at this stage of litigation. Second, the court holds that whether Youngblood may file a counterclaim against Jermaine Jakes, a non-party, is not fully briefed. The court will not address each proposed claim in turn. Counterclaim against Jakes. Federal Rules of Civil Procedures, Rule 13, permits a party to file a counterclaim against an opposing party in its answer. There is no requirement to seek leave from the court to file a counterclaim against an opposing party unless a party is seeking to amend its previously filed counterclaim or to file a counterclaim that matured or acquired after a party filed its answer. So basically, you haven't even filed an answer yet, and you can always do a counterclaim at the same time that you file your answer. So spending 2-3 pages on that you are allowed to file a counterclaim was a waste of pages, and you should have been focusing perhaps on this whole analysis on whether this statute even applies to your motion. So then it goes on to say, Youngblood has not yet filed an answer. He may file a counterclaim against Jakes in his answer under Rule 13. He need not obtain leave from the court to file this counterclaim. So then it has a footnote. Although Youngblood does not require leave from the court to file his proposed counterclaim against Jakes, the court notes that Youngblood proposes bringing civil claims against Jakes and Jermaine Jakes for violating criminal statutes. Proposing bringing a civil claim under 18 PACS in Section 2709 and the Texas Penal Code. Neither statute provides a civil cause of action. So basically, they're letting you know, if you're going to file this counterclaim based on this civil, honestly, I skipped over this part on the reply because I didn't even understand why it was being talked about. But it sounds like in the reply, they were saying that they're going to bring it, the counterclaim, under the Texas Penal Code and some other civil claim under 18 PACS. If they don't allow you to have a civil cause of action, you can't bring it. So the court is saying the statute that you talked about, there isn't even a way that you can bring it under that statute. So it's kind of giving you the heads up that if that's your reason to do the counterclaim, you might want to not do it. Like if that's your only reason, then you might not want to do it. So anyway, joining Jermaine Jakes as a counterclaim defendant. Youngblood alleges that Jermaine Jakes sent him a message on social media on November 3rd, 2024, stating, "You might be in dangerous territory, Duane. Just be careful." Youngblood seeks leave to join Jermaine Jakes as a party to this litigation based on this conduct. Federal Rules of Civil Procedure 19 and 20 govern the addition of a person as a party to counterclaim. You see how people, what we learned in law school, one thing they did tell us was we have a whole class on Federal Rules of Civil Procedure. Hated the class, really did. Hated the long arm statute and can you file in this state, and if it's diversity and all of this, like this analysis and the Erie doctrine, and we made like acronyms to try to remember it for our tests and stuff like that. You can lose off a procedure if you don't know your rules, your federal rules, your local rules, and it's the same thing in state rules. You can lose if you do not know your rules. So rules are very important if anybody out here in this chat want to practice. And that's why a lot of times your paralegal is very important, because they half the time they know the rules better than you because they have to look it up all the time. If they have to file something, there are local rules, like in Michigan, in our district, our federal court, we have a local rule in the Eastern District. Our font has to be 14 points. Like we have to put at the bottom how many word counts it is, and what processing system we use. So it was 5,000 words in Word, and it's 14 pound. Like you basically have to put a whole little thing at the bottom that you comply with the rules. So anyway, Youngblood seeks leave to join Jermaine Jakes as a party to his litigation based on his conduct. Federal Rules of Civil Procedure 19 and 20 govern the addition of a person as a party to a counterclaim. Rule 19 determines when joinder of a party is compulsory. Rule 20 applies to permissive joinder. Thus, the first issue the court must address is whether Jermaine takes in a necessary party or whether his joinder is permissive. Okay, I'm not going to put y'all through that either. On whether he should be joined as a party. Neither Youngblood nor Jakes addressed the Rule 20 standard in relation to the proposed counterclaim against Jermaine Jakes. Given that this issue has not been fully addressed by the parties, the court will deny Youngblood's motion to join Jermaine Jakes as a counterclaim defendant without prejudice until this issue is properly placed before the court and fully briefed by the parties. As discussed above, the court cannot and will not craft arguments for the parties. Footnote 7. Jakes argues that Youngblood cannot file a counterclaim against Jermaine Jakes, a non-party, because the court does not have personal jurisdiction over Jermaine Jakes. The court will not address this argument at this stage of litigation. Jakes cannot assert a personal jurisdiction defense on behalf of a non-party. So basically, they argue that they can't add Jermaine because he's a non-party, and they're saying you can't argue on his behalf because he ain't a part of the lawsuit. So basically, in conclusion, after all of that rigmarole, y'all ain't hear nothing about defamation. I warned you. You ain't hear nothing about civil conspiracy. I warned you. All you heard is a bunch of civil procedure lessons up in here. In conclusion, for the reasons, the court will deny Youngblood's special motion to dismiss pursuant to the anti-SLAPP, deny Youngblood's motion to file a counterclaim against Jakes as moot, because basically you could have did it anyway. Deny Youngblood's motion to file a counterclaim against a non-party, Jermaine Jakes, without prejudice. An order of the court will follow. So there was an order that says basically all of this that followed. Do y'all got any questions? Please go ahead and hit the like button. Y'all got any questions? Miss TT said Youngblood failed his course. Listen. That was a lot of procedure, and it just lets you know how deep it gets, because this is why attorneys sometimes they do get upset, because I get aggravated. I went to school for this, and I'm not saying that my point on here is to educate, and I by no means don't know everything, and I tell you guys I don't know everything, and I practice in one state, and I dibble and dabble in other states, but my primary is the rules and regulations up in this here state. But it gets difficult just because I get it. TV makes it look so glamorous. But look how the dang on boring this whole opinion was. Look how boring it was. This is what we have to do. You have to make sure you follow the rules and you know the rules. This is a part of what we do. And it was a big part, in my opinion, that was missing. Well, I think the court basically said it. That was missing in that reply. How do you go over? Let me see if I can find his motion. How do you literally don't even really talk about something that is so important as this? Are you able to even bring this in this court? I don't know. Let me see if I could find. I'm gonna pull it up real quick so y'all can see what I'm talking about here. Thank you. I've been on every day this week almost. Thank you guys so much for all of the support. We are growing. I think we hit 36,000. We did hit 36,000. So thank you guys so much. I appreciate it. So this was the response, okay? So this was the part that this is how much he spent on it. Pennsylvania anti-SLAPP law applies and warrants dismissal. Y'all see that? That's it. Do y'all see that? Y'all see that long tent, at least 11 of the pages the court went through the analysis. This was the analysis where you see this sub 2 that says Pennsylvania anti-SLAPP law applies and warrants dismissal. Part of the B is somewhat a part of it, I assume, and that's it. This part right here, that was the analysis on that. But let's go down to the court has jurisdiction over Jermaine Jakes, because I don't want to make it seem like I'm just saying that, because I remember reading it. The whole Jermaine Jakes situation, he goes over the long arm statute, the effects test, the conspiracy jurisdiction, due process is satisfied. Why are we spending this much time on something that you had the ability to do in the first place? And then he does spend some time. He spends a lot of time on attorney fees. Well, not a lot, but he spends a little bit on attorney fees. But this is the part on Jermaine. I just felt like it wasn't 2 or 3 pages. Maybe I just exaggerated. But you went through all of the tests and stuff, and it wasn't even like, I don't know. You said $2K an hour is not enough. Thank you so much. Thank y'all for making it seem like appreciating our job, because it's not awful. Yeah, when you get in court and you argue, that's like the finished product. But getting there, making sure you follow rules and procedures, and arguing about whether something applies and whether it's state law or not, going through different tests to see if this applies and that don't apply. It's boring as heck. And I hate it in law school, and I don't really like it now, but it's a part of the job. So I hope y'all hit that like button. Do y'all got any questions? Basically, he lost because the court deemed that it didn't apply. So, but the court said, obviously, you can still refile and do it right under the right rules. Thank you, Ms. Buckeye. Thank you so much. Thank you. Thank you so much. All right, y'all. What else y'all want to say? We done been on for an hour, and I skipped over about 10 pages. Bottom line, if you just came up in here, T.D. Jakes has prevailed on the motion. Now what will happen next is basically, let's see, what will happen next is that they will go to their original conference. And at that conference, they will say, well, how much discovery do you think we're going to need? How much discovery you think you're going to need? How many days? You go into the whole, when is your initial disclosures due? So now you actually have to litigate at this point. Now he's going to have to fight this nice 2-3 law firms that they have over here. And that's going to be Duane Youngblood, who does have Blackburn as his attorney. So Blackburn's going to have to roll up them sleeves and get to work. Because, yeah. Thank you, Sherry, for the Cash App. I appreciate it, huh? That is so kind of you. So, yeah. Do you think he will resubmit? I think he probably will. He just needs somebody else on his team. I said he need a paralegal because I didn't like the way I felt like it just didn't look as professional enough for me. Like, y'all know how I am over here. So I felt like he just kind of needed a paralegal that could at least assist him and take some of that off of him. But it does cost money for that. So you have staff and all of that. It is expensive. But I think personally, hopefully he has mentors, and maybe he can have a mentor that can help him with drafting some of this stuff and doing it in the way. Because the court did not argue it for him, did not rephrase it for him, But what the court did do is give him a little bit of breadcrumbs on how you can do it. But I already know. I'm about to see probably headlines about how Duane got his butt whooped and all of that. And honestly, it really wasn't the case. Y'all seen the document. I ain't hold nothing back. There was nothing about the substantive of the case because the court can't get there if the statute that you brought the motion under doesn't apply. The court can't get there if the rule that you brought it under doesn't apply. So basically, the court just explained why procedurally it wasn't under the right rules, and that's just what it is. Girl, when I see the fake trials on TV, it's scary. The whole time I'm saying that would never happen in real life. Yeah, and I say that all the time. Do they have some of course they loosely base it off. They get attorneys and they get people that are on their Daniel, have a seat. They get attorneys and so it's loosely based off of like real life situations. A lot of times, like Law and Order, you can kind of see some of the things that it seems like it mimics that's out in the media. And they have attorneys that are on their team that become executive producers, but they have to still make it where it's interesting to the audience. So just like how I lost half of y'all 20, 30 times going over this whole boring arse opinion, that's how it would be on TV. So they have to have a factor to keep you engaged. This is not engaging. I didn't want to read all of this. I don't like doing it's a part of what I have to do. It's not just you go in and you get to win $1 million in a civil lawsuit. No, you need to know the rules. So a lot of these shows, they make it where it has the drama effect for it. So no, you don't have, and it used to be hard for me to watch certain things like Law and Order because I would take it like real court. So it'll be times I'm like, why didn't you object? Why did you rule that way? That's not admissible. That doesn't even make sense. Like I would take it and then it's like, Pam, this is really like a drama, but it makes it look really fun. It makes you want to be a lawyer. And then that's another thing I've seen on TikTok. It's like people that are in law school, a lot of times lawyers will tell other people, go do something else. I'm not going to do that because I had one of my best friends from high school. She was a lawyer before I was. I didn't become a lawyer until I was in my 30s. So I didn't go straight to law school. I had a whole nother career first. She went to law school right after. So she's like 7 years ahead of me because she went to law school right after undergrad. And when I told her I was going to go ahead and go to law school, I already talked about it before. But I never, I spaced it out in life, how life was going. And when I told her I was going to go to law school, she was like, girl, don't you do it. Because it's not what people think that it is all the time. It's not just glamour. It's not just glitz. It's a lot of hard work. It's a lot of long nights. It's reading documents over. It's learning the federal rules. It's learning the state rules. It's learning your judge. It's dealing with somebody on the other side that may not be as, that may be a little bit overly zealous and maybe a butthole, to put it plain. It's dealing with a whole lot. And if you do civil, you may not see $1 for 2 years because a lot of times you take it on contingency. If you do plaintiff's work on the defense side, it depending on how much you have a love for what you do, it's a lot of sleepless nights because who the heck want to go into the courtroom with 2 people and you the only one that leave out because they go to jail? Like, it's a lot to it and it's a lot more. So it's not what people think that it is. And so I do see people on TikTok. I don't discourage people from going because I love what I do. But did it take me a while to get to the niches of what I love to do? Yes. And I think the problem is you see these shows like on Netflix, Hulu, everybody's in New York for some reason. That's the spot, New York. So everybody's in New York. You got the high-rise apartments. They seem like they do all of these Annalise Keaton moments. You go into court, you come with your smoking guns. It's like, oh, this wow factor. You leave, everybody meet at the local bar, and then you go to your high rise. It's like they got all this socialization time, but then they doing all this great work in court and making all this money. That's not how it goes. And if you come out and you say, I just want to work in big law, that means one of the biggest firms that they have in America, and you go work at the firm, they're going to put you where they want you to be. So if they got to open it in tax, you going to tax. If they got to open in secure transaction, you going there. If they got to open it in bonds, then that's what municipals and you're going there. Immigration, you going there. And then you go to that department and you may hate it. So then you like, I don't want to be a lawyer because you hate what they put you at. But that's one thing I did know because of the people, the attorneys that I knew. I was like, I want to work at a firm that does a lot of areas. And they be a boutique firm. So the firms that I've worked for, they've all been solo practitioners or 2-3 attorneys. Because what happens is in that area, you got to keep the lights on. So we learn criminal, we learn family, we learn personal injury, we learned medical malpractice, we learned police misconduct, we did a little landlord tenant, we did I was able to see what areas of law that I would be interested in doing. So I wasn't just confined. So I know things so there's a lot of areas I know how to do, like family law and all that, but I just don't like it. But then I have friends that they love it. Like they love the drama of family law. I don't do drama well. I don't go back and forth, as you guys see. I let people talk about me and I don't care. So I don't do drama well. I never have. So either we gonna fight or we not. That's kind of like how it's always been. So Danielle said don't fight. Okay. But I'm just saying, so I don't do that well. But when it comes to family law, it's just a lot of drama. If it's a divorce, why they dropped the kid off 30 seconds too late. I want to file a motion because there's a lot of emotion with it, right? So that's one thing that I don't do. But anyway, that's just my conversation. I don't want to discourage nobody in going, but it's definitely not TV. There's a lot. This order is probably the order that best depicts what a lot of attorneys have to deal with the procedural standpoints of it, and how it's not always glitz and glamour. And again, like I said, there's going to be people that swear to goodness, oh, T.D. Jakes for the win. He just won substantive, because they don't really know. They just like a win is a win is a win. Like that's how they looking at it. And again, it's a win on his side. I'm not going to say it's not. You win how you got to win. That's just a win is a win. Okay. But I'm saying how it's going to be relayed, I'm pretty sure, except the ones that's watching me that don't say nothing in the chat, but they want to see my commentary before they go do theirs, so that they can sound like they know what they're talking about. But that's another conversation for another day. But that's what it is. Basically, as you said, it was like, basically it was the statute don't apply. So nothing else. There was no analysis on whether they said it's a conspiracy. There's no analysis on whether there's actually defamation. No analysis on anything at this point. I'm not. I was just saying. She just heard me say that. That's why she said it. That's why it's hard watching nursing-based shows. Being a nurse is hard work, and no, we are not all chasing doctors. That's from They Say You're Nasty. Yes, I know. It's not glamorous. Everybody always shows the time where you guys are off in the break room or something like that, or you done saved everybody's lives get saved. No, there are times when lives don't get saved, and you got to go home with that. There are times where babies come out with issues, or they come out and they not even hit, they're already dead. It's so many different things that TV glamorizes a lot of things that don't need to be glamorized. So that's why I think a lot of people go to law school, and I have friends that went to law school, passed the bar, practiced for a good year, and they never went back. I'm like, all of that hard work and passing the bar, and you just like, no, I'm just gonna not practice. I had somebody I went to school with that immediately went to go be a teacher. I'm like, what? Because they went and they started working, and you excited and you happy you passed the bar, and then you turn around and you like, no, this ain't even what I thought it was. So, but that's that. Hey, West Side Story. Hey, Nestos Bond. But that's all. This was just a quick little live. So do you guys have any questions? I'm open for a couple of questions before we get off. I don't know why it's so hot in here.
I'm not hot.
You not hot?
No.
Maybe it's just me. Maybe I got heated reading all them federal rules. I told you it stressed me out. Marcus, you stay in Amazon, don't you? Work a lot over there in Virginia. Thank you guys for supporting the platform. Again, make sure you hit the like button. If y'all don't have any questions, you know, I was just chit-chatting the last few minutes anyway. But that's the basic update. We've been waiting 2 months for the court to say that statute does not apply in federal court. Try again. If y'all want a summary. And try again. That's it, and that's all. But I'm gonna get back to what I was doing, and you guys get back to what you're doing. If something else breaks, you know, I'll be back. You know, I've been on all week. I did good this week. You guys have supported. You guys made me want to do good. You know what I'm saying? You guys have supported and showed your love on all of the lives, and I appreciate that. So anyway, make sure you hit the like button, subscribe to the channel. Thank you to all of the new subscribers, and welcome. And if something else breaks off, we'll be back on. We'll talk soon. Have a great day.